All right, I'm just going to give this a minute while we get people joining us.
Great.
All right. Hi, everyone. I'm so excited that you're all here. For those of you who don't know me, I am Natalie. I'm a co-founder of Practice Better, and I'm really excited you're here today. I'm really excited. This is our first of many live trainings that we're going to be doing, trainings and webinars focused on best practices and common questions we get from you. So just another way that we can support you in your business, whatever stage you're at. So today, I'm totally stoked about this. We're joined by none other than Lisa Fraley. She is the legal guru for health and wellness professionals. And I hope you don't mind I'm calling you that, Lisa, but you really are. She's an attorney, a legal coach. She really practices she really practices law in a holistic manner, which is really unique. So she blends her legal expertise and her health and life coaching skills to help other heart-centered entrepreneurs protect themselves and their brands with contracts, disclaimers. She offers DIY legal templates, online courses, one-on-one services. She does podcasts. I mean, she's just got, honestly, a wealth of knowledge that we can all learn from. So hi, Lisa, welcome.
Hi, Natalie. Thank you for having me. Thank you so much for inviting me to be with you and everyone who uses Practice Better. I am a health and life coach as well as being a former healthcare attorney in a large firm. So I get the holistic world. I get the licensure world and the unlicensure world. And I'm just happy and honored to be here with you.
Awesome. So we actually Lisa, we got hundreds of questions. So we're really stoked and we're really excited to try to, tackle as many of these questions as we can in this hour. So for those of you joining us live, you also have this Q&A at the bottom of the Zoom pop-up. So if you have questions that come up as we're going through with Lisa today and questions that we don't get a chance to, or that you don't hear come up, if you had a question, just pop it into the Q&A and we're going to do our best to get to as many of those as possible. All right. I guess I should have done this little housekeeping before, but can everyone hear us and everyone see us? All right, I'm getting a hands up. Yes, awesome, Craig, you can hear us. Angela, you can hear us. Kendra, fantastic. All right, so we're live. Okay, so we're gonna just jump right on in here. And we, as I said, we're starting off with, we wanna bust some of those legal myths that we've been told time and time again. And we want to set the record straight once and for all. So Lisa, can you tell us once and for all, what is the difference between legal disclaimers, waivers, consent forms, and agreements? I mean, I think we all been told different things, and we kind of use them interchangeably. So what's the deal with these?
Totally.
And how are they different?
Exactly. And people have so many questions about the law, which is totally understandable, right? Because anytime any of us get outside of our own area of expertise, we feel like we're swimming upstream, speaking a language we don't know how to speak. So what I love to do is actually help make the law really easy to understand, so you don't have to be scared of it. You don't have to hate every lawyer under the sun. And so that you can actually have the information that you need to protect yourself and your practice and your brand, and just to kind of give yourself more confidence and security and safety as you go out and expand your work without worrying about someone coming after you and suing you. As we dive in, to answer your question, Natalie, I just want to share with everyone, this is informational and educational, right? We're just doing an informational webinar that I am obviously based in the United States as an attorney in the US, but everything that we're sharing here applies to anyone who has an online business around the world. So if you're in the US or Canada or Australia or the UK, this is information and education to help you understand how to operate in the online space. And having said that, you also always want to have a local attorney in your back pocket to be able to help you with local issues that come up as well, and to make sure that all of your legal documents comply with your local laws. But part of the reason I got into this and helping people understand contracts and agreements and waivers is because, when we don't have someone to explain it to us, it feels like muddled alphabet soup. And so to answer your question, what I wanted to share with you is that basically there are just a few forms that you need to have in place when you're starting your business. Depending on what you do exactly and how you do it determines the legal document that you need. So sometimes, you know, if you have a website, you need to have a website disclaimer on the website. But if you work with one-on-one clients, you need a client agreement. And if you have a group program or online course, you need terms of use. So there are different legal documents that you need based on different things that you do. We can dive into those more specifically, but it really, there's no one size fits all legal document, just like there's no one size fits all diet.
Right. So what's the difference between a disclaimer, a waiver, a consent form, an agreement? Like I know, yeah, I know some of these pertain to the type of service you're offering, but
yeah, totally.
What's the difference?
Okay,
yeah.
So when we talk about, a lot of people will use the word disclaimer or waiver, which can mean a lot of things. But when a lot of people are talking about like a form that someone signs when they come to work with you, and it lays out some legal language, and at the bottom they sign their name and they date it and give it back to you. And basically the practitioner is saying, hey, if you know, when you come to my yoga class, or if you come to my training, or if you're enrolled in my course, I'm not responsible for what you do with the information. You still have to use your own professional judgment or your own personal judgment. And it's signed by one person. So a disclaimer or a waiver is usually a form, a waiver form that's signed. Now that's something that you often want to do if you're having a live event, or you need something quick. But if you do a program, a one-on-one program, I actually recommend that you use a longer client agreement, which is actually a legal document that's signed and dated by both of you. The reason for that is because usually a disclaimer or a waiver is one-sided, which means you, the practitioner, are saying to your client, here, you know, this is what you're agreeing to, sign your name. But a contract is where both of you say you're doing things together. So for example, the practitioner is saying, I'm offering you these services in exchange for you paying this money. And you're saying to the client, I need you to show up in these ways and recognize that I'm not giving you advice or whatever. And you both sign your name. So contracts are stronger legal documents than just a waiver.
Right. So the contract is, it's a commitment or an agreement or an understanding between two people. It's not just that one-sided, like you said.
That's right.
That's really helpful. So you would use these contracts or these agreements for a one-on-one coaching, for online programs and group programs?
Okay. So every lawyer does it a little bit differently, right? So Natalie, the way that I come to the law is actually from a practical standpoint and sort of a spiritual or energetic standpoint. And what I mean by that is I help you take legal protections and get legal language in place to protect your programs and your content and your website. And when you take these steps, you're creating energetic boundaries and guidelines around your space to create a stronger container to hold and support your business. And I believe personally to attract to you people who are aligned with you as well. Right. So it's an and, which is why I have an and right here. And so having said that, just to help people understand, if you're having a one-on-one program, okay, you're a practitioner offering one-on-one, and let's for right now say you're not licensed, okay? You're not a doctor or a massage therapist or physical therapist. You're operating as a health coach, a wellness coach, a business coach, some other type of spiritual healer, some type of online entrepreneur. You're gonna use a client agreement. Okay. Client agreement where you both sign the document, okay? Again, that's because you want to show up in a certain way. You want your client to show up in a certain way. You both agree, put your name on the document, and you have clarity and peace of mind and ease and really strong, clear boundaries about your client policies. Now, over here, in contrast, let's say you have a group program, okay, or an online course that you're selling, or a downloadable info product, or a self-study course, or a book, or a CD, or something like that you're selling through your website. Anything that's not one-on-one, basically. Then you want to have what I call terms of use. Now, some other lawyers call them terms of service. They have different names, but this is basically more the one-sided document where they check the box and agree to the terms. And in Practice Better, of course, they can upload these terms and put it into Practice Better, and the person can check the box. Now, really, that still can be very binding and very legally binding is the word that we use, but it means like you can hold the person to it. You can bind the person to the document, even though it's one-sided. Those terms are usually very long and thorough. But yeah, client agreement for one-on-one, terms of use, checking the box for group programs, online courses, etc. Awesome.
So that's a really good point. And Lisa did touch on that whatever you're using, so these terms of use, if you want to insert them into your Practice Better bookings pages, you can do that. You can create it first under what we call a disclaimer, because it's used for a couple different reasons, and then add it to your terms and conditions in an actual service. And I can send you a link to that when we send out the replay. There will be a replay. And then also what you can do, if you actually require a signature from the person, booking your service, then you can also add a form to the actual bookings page where you can collect that signature right then and there.
And that is so fabulous that you do that, Natalie. We had a nice conversation before this webinar today, and I was so excited to see all the things Natalie does well and does right and does correctly to make it really easy for you all to get your legal documents in the right place on the back end. So Natalie knows what she's talking about. She's all things different names a little bit sometimes, but we're talking about the same thing, and she understands. So if you have questions about that, she can help you on the back end too, or her team can as well.
And just one other piece to that is if you are doing an agreement that Lisa talked about that requires 2 signatures, right? A signature from your client or patient and a signature from yourself or by yourself, you can create an automation in Practice Better for this. So you can't include a form in your bookings page that requires 2 signatures, just the client signature. But you do have an automation that can send out that form right after they've purchased that will give them an opportunity to sign, and we'll also have your signature on there as well. So we can talk about that offline. We don't want to waste too much time. We want to talk about the legal stuff here. So one question about these forms. So does this differ if you are a licensed professional versus a non-licensed professional? Okay.
So, and this can get a little complicated, so I'm going to try to make it as simple as possible. But obviously, if you're a licensed practitioner with a brick and mortar practice, and obviously you're following the laws of your own state and your own country with your practice, but when you have a medical practice, usually in the US, we call it an informed consent form that your patient is signing. It's a one-sided form the patient signs. Now, licensed practitioners cannot actually enter into 2-sided contracts. It's just they're not allowed to do that. It's always disclosure of the risk to the patient signing the informed consent. So for licensed practitioners, this is why often if you're doing something in the online space, the terms of use help you if you're selling a group program or online course, which is not going to be considered the practice of medicine because it's group and not personalized. It gets trickier if you're doing one-on-one work, and so we can talk about that. But brick and mortar, you want to do an informed consent, and then in the online space, you would do something different.
Okay, that's clear. Was that clear to everyone? I know we have so many different types of practitioners using Practice Better, licensed, non-licensed, and then some who are licensed and also practicing as health coaches as well. And we'll touch on that a little bit more a little bit later in our webinar. But so once and for all, once and for all, right? Generally speaking. So what are those, on top of those waivers or consent forms or agreements that we just talked about, what else do they need? Does someone just starting out who's working with clients online or in person, what do they need to protect themselves and their businesses?
Good question. So one of the things I do to make this all easier to understand is I actually align legal steps with the chakras of the body, the energy centers of the body that go from the root to the crown. And most health coaches and holistic practitioners are familiar with the chakras, or at least have heard of them, and they understand that goes from 1 to 7, which is great. So usually when we talk to people about what do you need to start out with, and by the way, I do have a podcast episode in my Legally Enlightened podcast that walks through this, since we're going to kind of go through it kind of quickly. The podcast is only 20 minutes or less, all of them are, but that can help you. But basically, Natalie, the first step that I align with the root chakra is what I call the website disclaimer. Okay. And this is the base layer of legal protection on your website that is a document that's linked through the footer of your website. Okay, so it's not just 2 sentences at the bottom of the website. It's an actual document that's a couple pages long that tells people who you are and what you do and what you don't do. So, for example, if you're a health coach, it tells people, I'm not a medical practitioner. I'm not giving you medical advice. This doesn't replace the information advice from your own doctor. If you have affiliates, it talks about affiliates and testimonials. And it's a very, and it explains your liabilities well, but it's a lengthy document. Because in the law, if you don't say it, it's really hard to prove. So our online world tries to make everything short and sweet, but in the legal world, you actually need to have some heft in your documents. Right. So that's the first step. And then the second step is usually the client agreement that we just talked about, because most health coaches or online practitioners are starting out with one-on-one clients. It's the easiest way to receive income. That helps you create those client policies and strong boundaries and getting that in writing signed by both of you. And I do see quickly that I think someone was asking, Cheryl was asking about when people fill out forms online. Yeah. And they're just quickly, just so you guys all know, you can still have someone print out a contract, sign it, and scan it back to you. You sign it, and then send it back to them. Or you can use an online version through Practice Better, which is much easier, that Natalie's team can help you set up. But the idea is, yes, you both want to end up with a signed copy of the full document when you're done, whether electronically or by paper.
Right. And is there a time frame that they need to hold on to that for?
Okay, so in the United States, and again, I'm sorry I can't speak to Canada and other countries, but in the United States, and you guys may already know this yourselves, our Internal Revenue Service, our tax entity, can audit you personally or your business for up to 7 years. So I recommend that you keep those contracts for at least 7 years, because if you have to prove your sources of income, you can prove you had a client agreement with someone, they actually were your client, they did pay you, or they didn't pay you, or whatever the case may be. So 7 years in the US, and you may know for your own country what the length of time is that you want to keep all of your receipts, all of your business receipts, and personal receipts as well.
All right. Does that apply to health records as well, Lisa?
Yeah.
The same 7 years?
I would. Well, okay, so I'm a lawyer, so
yeah.
I come from the perspective of keep everything as long as you possibly can, okay? Because especially when things are electronic, you can put them on jump drives or zip drives, you can keep them in your old computer, you know, your hard drive, you can keep in your basement or your closet or whatever. Like, it's just a good practice not to get rid of things, even in the paperless world. So at least 7 years, but as long as you can, really, honestly.
Okay, awesome. Alyssa, does that answer your question? All right, awesome. So if we look at another misconception, at least, you know, something that's just not straightforward. So everyone thinks that they need to be HIPAA compliant.
Yes.
So HIPAA is a big, it is very important.
Yes.
Very important, but it's also very important to understand who needs to follow HIPAA, what countries or country does it apply to, and what is it, you know, I guess let's start there. Who needs to be HIPAA compliant? Let's make this nice and simple.
This is so funny when we talk about the law. We'll ask like a super simple question and it has like a very long answer. So I'm trying hard to keep this concise.
Absolutely.
People be like, oh, I just have this quick question and it takes like, 20 minutes to write back. Okay, but anyway, okay, who needs to be HIPAA compliant? So this is quite fascinating. A lot of health coaches have the misconception that they need to be HIPAA compliant. And in most, but not all, most cases they don't. And here's why. Because HIPAA compliance applies to health covered entities and also healthcare practitioners, licensed practitioners, just as a shorthand way of describing it. The statute spells it out differently. But basically, if you're a licensed practitioner or you work for a covered entity like a hospital or something like that, then you need to be HIPAA compliant, okay? If you're working with patients, if you're gathering patient information, patient data, you need to be HIPAA compliant and use a HIPAA compliant platform, which Practice Better is, which is great. Now, if you're a health coach, you still want to use care around the confidentiality of the information you're receiving from your client. Other countries like Canada and the European Union, who just passed a huge regulation this spring called GDPR, you all treat privacy with such more care than we do in the US. You have higher and stricter privacy policy standards. So I always encourage every health coach or wellness practitioner, unlicensed practitioner, to also have confidential medical records or confidential records, but they're not medical records. They're not medical records. If the client is just sharing that information with you in your health coaching relationship.
Okay.
Make sense?
Yeah, that's fantastic.
And by the way, really quickly, Natalie, the client agreement and the terms of use we talked about has confidentiality language already in them, at least the ones that I create, and most should, to help foster that.
Yeah. And also too, we'll talk a little bit more at the end, because I know we have questions about you know, what do these disclaimers look like? What do these agreements look like? Lisa has some fantastic templates that she sells on her website. We're going to give you a really awesome promo code at the end of the webinar to use with those. And they're way more thorough than what we would be able to get into right now. Yeah, Lisa's thought of everything.
Right.
Now, one more thing on this HIPAA. Does it change if you're taking insurance or not?
Okay, great question. So typically, if you're taking insurance, typically at least in the US, you are a licensed practitioner, because some states you can, but most unlicensed practitioners don't take insurance. Sometimes you can.
Right.
It really comes back to, is the information a medical record, and are you a healthcare practitioner? So the insurance itself isn't really the factor, Natalie. It's whether the information is considered a patient record and you're considered a covered entity. And just so you guys know, when your client is telling you about their health situation and what they're eating and what their physical condition is and their symptoms or whatever it is that they're dealing with, that they need your help with, they're voluntarily sharing that with you. It's about their medical situation, but it's not a medical record at all. They're just voluntarily sharing that information with you.
Right.
You want to keep it safe, but that's very different than being required to protect it under HIPAA or even GDPR, and make sure that, you know, you don't disclose it without their consent.
That's a really, I think you cleared that up quite a bit. That's fantastic. So you did touch on GDPR. Which did put us all a little bit into a frenzy earlier this year.
Yeah.
So things seem to be calming down around that. But we also want to make sure that people understand not all of GDPR. There are local resources. Lisa, I'm sure you have resources on that as well that we could link to. But can you just quickly let us know who is affected by GDPR? Does it affect practitioners in the US or Canada or Australia?
Okay, so the European Union and some other countries basically came together and updated and made much stronger their privacy laws. This is a giant regulation of 250 pages long, which I have read the entire thing. And basically, you don't need to read the entire thing, but basically what it's saying is that if your client or your person who's subscribing to your newsletter lives in the EU, works in the EU, or is visiting the EU when they're joining your list, for example, then you are subject to GDPR, okay? And that means that you have to get what we call in the law express consent, overt express consent from them to join your list. So for example, in the past, we would have an opt-in where you say like, learn my 5 ways to make, 10 meals in 10 minutes. And they would click in and get the free gift, and then you would add them to your list, right? Your weekly newsletter list. You cannot do that anymore with GDPR. They have to agree to receive your weekly newsletter list. Now, there are ways you can say that, and there's numerous ways you can do that with check boxes and opt-in boxes and auto responders. There's like 3 or 4 different ways you can do it, but you need to be aware that that is a significant change, and you can't just like add people to your list without their consent anymore. That's one big way. And you need to have a privacy policy on your website that's very thorough and updated with GDPR language, letting people know how you use their personal data. If you take health information from them, you have to even add even more language for that. So you want to make sure you have an updated GDPR-friendly privacy policy on your website as well. Yeah,
that's really clear. So just to kind of let everyone know that if you are in the EU or you're seeing clients in the EU, or you think you might see clients in the EU, you can also, again, in Practice Better, put this information, so whatever GDPR consent, right? Like consent to you to use and store their information, you can put that on your bookings page. Okay, so you have that tool available if you need to use it. You can do that right from your bookings page, so that way your clients or your patients are advised before we collect any information of what you plan to do with that information and how you plan to store it. So am I right in assuming that really regardless of where you are, you should be telling your clients what you're doing with their information and how you're storing it?
Yeah, and it's always better to err on the side of caution, I believe. And it's
Yeah.
much easier to protect yourself on the front end. It's just like drinking green smoothies and taking your vitamins and supplements on the front end. It doesn't
Right.
guarantee you're not going to end up in the hospital on the back end, but it can certainly reduce the risk of that. The same is true with the law. When you
Right.
put your GDPR privacy policy in place and you use your check boxes and what Natalie's saying, it basically, if you are anywhere in the world and you have a client in the EU, someone who works in the EU, or they are visiting the EU and sitting at a cafe in Paris and eating a croissant, and they click onto your list and join your list, then you have to follow GDPR even if you're in Australia. So
Right.
it's just a good thing for everyone to do, unless you clearly have you're a licensed practitioner with a brick and mortar practice, you only work with people in your state or your province, and you're not communicating with anyone else around the world, it's purely local, then you would not need to. But most of us in the online space are working with people all over the world.
Yeah, that's a really great clarification. So yeah, if your clients are even traveling, that's a huge thing, right?
Yeah.
So again, in the Practice Better, I don't want to spend too much time on this, but you can put this up in your, you can put this up on your bookings page. It takes 2 minutes to set up, and then you don't have to worry about it, right? So you can just set it up and then be done with it. Awesome. So we did have a question. So just letting you guys know, if you can move your questions over to the Q&A section, just because they're easier to keep track of. We did have a question from Cheryl about filling out online forms. So in Practice Better, there is an option for them to sign. So they can actually use their mouse or their touchpad to sign. They also have the option where they can type in their name and choose the script.
That's great.
Is one better than the other, or they're both just as legally binding?
No, okay. So you guys, the reason why you want to use Practice Better to do this, or sometimes people like to use like a Hello Sign or DocuSign or an online program, which is fine too. The reason why you have to have a third party verifying essentially the signatures is basically that person is affirming that they're representing themselves through that third party signature program.
Mm-hmm.
You don't want to just send like a Word document to someone and say, type your name, because their best friend could be on their computer and type their name. Now, we don't think that's probably going to happen, but legally it's hard to prove that it didn't happen. So using Practice Better to do that, whether it's a signature or whatever, as long as they're basically affirming this is my signature, that's sufficient.
Okay, that's very helpful. And I'm sure a lot of other people had that question as well. All right, so moving on to our third myth here.
We talked so long about each of these topics. We're really trying to just give a bite here for you.
Again, and also too, like, we will put as many links to different resources that Lisa has in the replay. Lisa also does like free 20-minute, am I right? Free 20-minute calls. So, or you can book more time with her if you need. But we just want to give you
free, and a book that's available on Kindle, and there's all kinds of low-cost resources for you, as well as legal documents and things that you can use in your business.
Lisa, that's amazing. Honestly, it's so appreciative of having you as a resource. So restrictions in terms of working with clients across state borders, provincial borders, or just internationally. So you hear people say that it depends on the location of the practitioner or the coach. You hear people say it depends on the location of the client or the patient. Which one is it?
Yeah, I know. And once again, it's a really simple question and not such an easy answer, but we'll do our best.
Right.
Okay. So here's how it works. Part of the reason why you want to have a legal document in place, like a client agreement or terms of use, is that it says in the document, there should be a section, there is in the ones I create, and if you use other legal documents, that's fine. Just make sure it says in yours that there's a governing law section, which says, hey, if we have a conflict, the law that's going to govern and be the law that we follow is the law of the state where you're based as a practitioner, okay? But it has to be in that legal document, because otherwise, like you said, Natalie, whose law applies? And then in law, we call that a conflict of laws, like whose law applies. So when you have that agreement at the outset, you've made it very clear whose law applies, first of all. Second, in terms of how you practice, if you're a health coach, let's say, and you're sitting in Kansas, let's say, and your client is in Quebec, let's say, right? How does that work? Well, you're going to be using a client agreement that says that if we have a conflict, the laws of the state of Kansas will apply. And you also, I'm just picking Kansas out of the blue, but that practitioner also needs to know what they're allowed to do and not allowed to do in the state of Kansas. That's a whole separate issue, right? Not only they need to figure out based on their own state law what they can do as an unlicensed practitioner and what puts them at risk if they're an unlicensed practitioner.
Okay.
So part of the things that we do is try to help people understand what their state law says generally, help them understand how to find resources for their state laws, and just to understand how to get that information, recognizing laws change all the time. In the past 5 or 6 years, laws in the US have changed from state to state and gotten more restrictive or less restrictive. So you always want to pay attention. Same is true in any province you're in, any state in Australia, anywhere in the UK or Europe. You want to make sure you're looking at your laws of your local area because they can change with every legislative session.
And do you have a go-to in terms of where our users can go to find out more information on their state or province laws?
Okay, so I have a go-to for the US at the moment,
Okay.
2 go-tos. One, the traditional website people have looked at is called nutritionadvocacy.org. And that is the website that basically summarizes state laws, actually has the text of the state laws, and then has a map on the front many people are familiar with red state, orange state, green state, and yellow state. Right. And basically it's like a stoplight. So if you're in a red or orange state, your laws are more restrictive about what you can and can't do with one-on-one clients. And if you're in a yellow or green state, you still have to read the fine print, but you usually have more of a green light to do one-on-one work with clients. That's a great starting resource. The second resource is holisticcouncil.com. And this is Council for Holistic Nutrition, which basically also summarizes the state laws in very simple, plain English language. And that's another space where you can start to read and understand your state laws. But I always recommend, no matter where you're located, this is something you do want to talk with an attorney who understands health coaching or online business, and who also understands licensure and laws of the state or province. Because you know, health coaching and wellness, it's all very new. And a lot of traditional lawyers, which I used to be way back in the day, they only know the licensure. Like if you're not an RD or if you're not a physician, you can't do this. That's just what they're taught, right? So there are things you can do. You just have to be very clear about what those are.
That's awesome. That's awesome. And I'll put these links in the replay as well. It's going to be a full-on email with this replay, but you'll have everything that you need.
We want you to help you get what you need.
Exactly. So in terms of language, so we have, like, again, we mentioned we have licensed professionals who also practice as health coaches. We have health coaches. We have such a spectrum of users in Practice Better. So what is a way to make sure they're using safe language? If someone is a licensed professional and they are practicing using their health coach hat, like how do they distinguish themselves, between the two? I guess that's the first piece.
Okay. And this is a big conversation. Okay. So first of all, I want to say that when it comes to licensed professionals who are wanting to do online work in the online space, this is all still very gray. Okay. There's not a lot of black and white in terms of, because the laws are not designed to say, here's what a health coach is, here's what a health coach can do. The way the laws are written is that they're written to say, here's what a registered dietitian is, here's what registered dietitians can do, which means that basically if you're not a registered dietitian or a licensed medical doctor or any other licensed number of professions that allow nutrition coaching, for example, or nutrition medical advice, then you can't do those things, right?
Okay.
So it's kind of backwards for us, right, as health coaches. So so one of the ways right now that could potentially reduce risk, but this is not guaranteed because it's very new, potentially reduce risk is to actually separate your medical practice from a health coaching practice. And I mean totally separate. 2 separate LLCs or S Corps, if you're allowed, 2 separate websites, 2 separate everything. Because the idea is that over here is your brick and mortar practice where you see your patients within your state or your province, you follow the licensure rules, you are very respective of your license. And over here, you have a health coaching practice where you're working with people online, doing group programs or online coaching, or in some states, one-on-one. And here is where you're making it very, very clear in your legal documents, in your verbal language, everywhere written on your website. I am not a doctor. I am not a registered dietitian. I'm not giving you medical advice. You need to work with your own doctor. I am here to give you information as a health coach.
Right.
These are resources and recommendations, but you need to work also with your own doctor.
Right.
And again, the idea is that it shows your intent to keep it separate. But again,
Right.
this is guaranteed because some people argue that you can never be separate. So it's tricky. We're just doing the best that we can right now with the laws, the way they're written, the way they are now.
Right. So that would mean not, yeah. So if you are working out of state, out of country, or cross borders, whatever that might be, that means you're not advertising yourself as a medical doctor or registered professional.
Okay, let's qualify that, Natalie. Okay, so here's the deal. If you're a licensed practitioner, if you're a registered dietitian, you can provide educational videos. You can do online courses. You can do group programs and things, as long as you're making it very clear you're not creating a patient relationship, and you're making it very clear you're not giving medical advice. But you can do that within your practice as just an educational or marketing component of your medical practice, okay? That's just, but we're not talking one-on-one. This is just group, video, audio, whatever. It's where the one-on-one work happens. That's where it gets really tricky, because anytime someone's in a one-on-one situation with you, and they know you have a medical background, you know, the idea is that we're afraid that they're going to think you are showing up as a doctor. And we want to make it very clear that you're not, and you actually don't want to be diagnosing, treating, preventing, or curing anything in a health coaching practice. Even if you have medical background or credentials, that is only done by their doctor, not you. You're the health coach.
Absolutely. Absolutely. Thank you. That's really, I think that's pretty clear. So in terms of safe language, can you give us some examples of safe language to use for, I would just say, you know, across the board for health coaches, because again, even though we have licensed professionals, oftentimes they're also certified as health coaches, and that.
And you guys, thank you so much for all of your patience and your questions. I keep seeing all the questions coming in. I can't answer all of them. Like, this is what I do. This is why I do this, because people have so many questions, and it's, law is not black and white a lot of times, just like nutrition, right? Someone can come in and be like, tell me what I need to lose 50 pounds. And you're like, well, what's your medical situation? What diets have you tried? Or do you exercise? Do you have health conditions? What's your genetics? What's your heritage? What's your blood say? What are your, like, it's the same
loaded question.
But when people, like, you know, just to see it that way is helpful, because you can ask, like, I just have a simple question, but it's a very complex area, just like nutrition is. So, okay, so basically these words are generally words that health coaches want to stay away from, or non-licensed practitioners. You don't ever want to do this, or you don't want to say that you do this. You don't want to diagnose. You don't want to treat. You don't want to prevent, and we're going to talk about that in a second. You don't want to cure. You don't want to heal. Okay, because the only people who can actually say that what their advice and expertise does is prevent disease or cure disease or heal something or treat something are licensed medical practitioners, and in some cases also licensed clergy members, depending on your state, because they can engage in faith healing. But everyone else, what you do to help keep you safe is, and if you do come from a health coaching perspective, or you were trained in a school of thought that believes in bioindividuality and that each person is different as to what they need nutritionally, then we recognize that people heal themselves. You are the coach who provides tools and information and guidance and support and love and care and hold the container and hold the space for them. And you may provide recommendations or suggestions, but they heal themselves. So you don't want to say, my program will prevent cancer. My program will heal you from fibromyalgia. Like, you do not do any healing. The client is healing. Okay. But if you think of it that way, it kind of helps to keep it straight, right? Yeah. So those words you want to stay away from. Also, in many states, it's not illegal to use this word by any means, but in states that are more restrictive, like the red and orange states, I do caution using the word nutrition at all. Because it's just, and meal plans also, they're words that are so associated with the work of registered dietitians, which we always want to respect as health coaches, right? There's a place for registered dietitians that we desperately need in our world. And there's a place for health coaches that we desperately need in our world, I personally believe. So we don't want to tread on other people's territory, and we want to just make it clear as to what you're doing. So I would just personally recommend choosing different words in nutrition and meal plan or meal planning, if you can, just to eliminate that potential confusion.
Yeah, that's awesome. Do you have any suggestions for different ways you can word those?
Yeah, of course. So for example, you can talk about, if instead of using the word nutrition, you can talk about healthy eating habits. You can talk about what to eat. You can say the word food. That's totally fine. Everyone can talk about it.
Everyone understands it.
Our whole country and world talks about food, that's fine. But nutrition gets into the macro and micro levels of nutrients and things like that, which just be very careful. You're not stepping into the world of RDs and licensed professions in states where you're not allowed to do that, okay? The other thing is, instead of meal planning, you can say recipes, recipe guide, like 5 quick meals to make in 10 minutes. You can say, weekly shopping lists, weekly recipe guides. Like there's a lot of different ways you can say it without using those words.
Right.
It's not illegal, but just use caution. Just use caution. And if you can't avoid it, it just makes it easier and cleaner for you.
I love those. Those are really great. I'll send those words out. Sorry, there's some construction going on. I will send those words out in this replay, okay? All right. So let's head over to some of these questions. Some of the questions that are a little less specific, okay? So if you have specific questions, just really like a personal scenario, I would definitely say link up with Lisa outside of the call. Because we want to be able to help as many people as possible with this short period of time that we've got left. So, Lisa, I'm going to scroll through the Q&A. So let me know, can you scroll through the chat and let me know if there's anything that sticks out at you?
I'll look at the chat. Is that what you're saying? You look through the Q&A.
Actually, let me scroll through the Q&A in the chat while we're on this topic of safe language. Supplements.
Yes.
Can you talk about working with supplements for different types of professionals?
Yep. Okay, so licensed practitioners, you already know that if it's within your scope of practice and within your licensure, you can make recommendations of dosages of supplements or specific supplements as part of a treatment plan. I didn't even mention I used to be a healthcare attorney in a large corporate law firm, and I worked with licensed practitioners. You're probably wondering, like, how does she know all this about practitioners?
Right.
So that's why I speak your language. That, of course, you can do as a part of diagnosing and treating someone and making supplement recommendations just like any other medication or any other type of lifestyle program or plan you would have for your patient as a physician or licensed practitioner, if it's in your scope of practice and within your licensure. If you are a health coach or a wellness practitioner or someone who's not licensed or operating over here in this online space, what you can do is you guys, here's the best way to look at it. If you can put it in a blog post, a chapter of a book, or say it on TV, you can say that to other people, to your clients, right? So for example, isn't that so cool? Like if you could say, like you're not going to go on TV and say, so someone living in New England should take 1,000 milligrams of vitamin D, but maybe if you have this medical condition, don't do that. Talk to your doctor. Like you're not going to get nitty gritty into the exact amounts because everyone is completely different. You might say if you live in the northern hemisphere, you want to talk to your doctor about perhaps checking your vitamin D levels and making sure that you're taking enough so that you can avoid seasonal affective disorder, make sure that you are depressed, make sure that your body, skin, bones, life, whatever is operating, brain is operating at optimal health. So if you can say it to everyone, then as a health coach, you can say that. You can say things like, I recommend that most people take a multivitamin, fish oil, vitamin D. I'm just totally making this up, right? And this is why I have the and, everything's an and you also want to say to them, be sure to talk to your doctor or medical practitioner before you start taking these, because they may not have disclosed to you as a health coach that they are taking some other medication that would be contraindicated with vitamin D or fish oil or whatever. So you can be very general, but always say, check with your doctor, always. And then you don't want to do, as a health coach, specific amounts. Generally, you could say, follow the dosage of the bottle. And as we know as health coaches, sometimes that's not enough. Like maybe someone needs a mega dose of vitamin C, not just 250 milligrams on the bottle. But you still have to say it in a way that would apply to everyone with caution and encourage them to talk to their doctor. That will, it's come from a place of education, not treating the person.
Right. Oh, that's awesome. I love the way you worded that. It was so crystal clear, and I think it's going to make things a lot clearer for all of us. I mean, you're right. So much of it is great, and we kind of also, too, we're like stuck. The legalese is not easy to understand unless you're in the legal world, even for us, we get questions and we're like,
well,
this
it's
is
just
not,
like people come to you for nutrition advice, right? Or Natalie, you on the technology end, like people are like, what? It's like speaking a different language. That's all.
absolutely.
A comment here I want to address really quickly, because I know some people are kind of stuck on the word prevent. Just let me address that really quickly.
Yeah.
You guys, the deal is you can say that as you as a health coach, you can provide tools. Your job is to provide tools, information, resources, a listening ear, support, guidance, questions, right? As coaches, we believe clients have the answers.
Right.
Coaches ask the questions. Medical practitioners are allowed legally, they have the answers. The patient comes to see them, the doctor has the answers. Coaches ask the questions to help the client get their own answers. Totally. This is why you can differentiate the two, because they're fundamentally different ways of approaching situations. Doesn't mean the coach can't provide information that's helpful. So when you're providing tools and recommendations and suggestions, you can say that your program may help prevent, may help reduce. It's just like on TV when you see all the wrinkle creams and you're like, this may prevent fine lines and wrinkles.
Right.
That it will, because they can't make that claim. That's a medical claim. They can't promise that. Yeah. And as a health coach, you can't do that either. So may help are good words to use with prevent and things like that.
Right. And it's also, it's also a nice security for us or I guess not for me so much anymore, but for health and wellness professionals, because that's a whole lot of pressure. If you were to say this does that, right, they might see a whole variety of benefits of working with you and going through, whatever it is, whatever plan that you guys have come up with together. But, if they don't get that one result that was promised, it also, besides being legally.
You don't want to guarantee results, like ever. I did a whole podcast. Do not guarantee results ever. Please, 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 please.
Yes.
Because you can't.
Right.
You can guarantee that you're going to give them tools and information and resources. You can guarantee giving all of the stuff you're promising you're going to give them in your client agreement, but you can't guarantee they're going to use it right then, or that it's going to apply to them right then, or maybe they're scared and they have to wait 2 years till they use it. You're not there at midnight when they're opening the fridge, eating chocolate cake with a fork because they can't sleep. Like you can't guarantee results. Like you just can't. So, but you can be sure to give them what you promised that you're going to deliver. Then it's their responsibility to come up with the results. That has freed so many practitioners, Natalie, when I share that, and I get passionate about it. You can tell I get all excited about it, because I don't want you to carry that burden. It's too heavy. It's too much. And if we do believe that the clients have the answers, they can only be responsible for their results. You're responsible for helping and guiding them.
Yeah, I can, and you know what, as you say that, it's true. I can absolutely imagine this weight being lifted off our shoulders, because we are in this space and we do want to help people because we care, right? But we can only do as much as we can do. It's really up to the client to do the real work, right?
That's exactly right.
So it takes that pressure off, and also to legally makes things much clearer and much safer for you.
Exactly. Because you guys we know that food is the doorway, but there's all kinds of blocks and limiting beliefs and relationship issues and perceptions. All these things often have to be worked through for the person to lose their 10 pounds or whatever. Like it has nothing to do with the food. It's in my school where I was trained, that's considered the secondary food. You have to get to the other things that are important in their life to really make the change. And so we wish we want to do it for them because we care so much, but we just can't do it for them.
Right. Yeah, absolutely.
Yeah. You guys, I get so excited about bringing the law together with the coaching, and because once you get clear on some of these concepts, you do feel freer. I hope you feel safer, you feel freer, you feel more confident to go out and actually spread your message farther and wider and help more people, because you know kind of where these lines fall into place.
Right. And so also too, with now labs being available everywhere, is that the sort of same guideline as with supplements, and in terms of like interpreting labs? So let's talk about labs for a couple of minutes.
Area in and of themselves, because some states require that only a physician in that state can order a lab that must be done in that state, and then the results need to be produced back to the physician in that state. Okay. So when it comes to labs, and I know a lot of you have functional medicine practices or integrative medical practices or functional medicine health coaching, functional health coaching practices, that when it comes to lab, you need to be very clear about what the laws are around where the labs are that you're using, number one. And number two, what I like to tell people is the safest way to do it, okay? And you always decide how much risk you take. The safest way to do it is to have the physician order a lab, have the patient go to that physician, go to the lab, come back, give the results to the physician, and then the patient who comes to you as a health coaching client gives their lab results to you as a health coaching client. They voluntarily share the results with you. That's not how everyone does it. That's the safest way to do it. And in some states, that's the only way you can do it.
Right.
If that's helpful. So then in interpreting those lab tests, right, again, you want to be super clear that you are giving information and education and helping them understand the lab test, but you're not diagnosing, treating, preventing, or curing anything, because you're not, and you're not allowed to. And they need to also talk to their own doctor about these results as well.
Fantastic.
And then you can prove, in some states, about half the states, you can do a personalized recommendation. You can create like a personalized nutrition plan and give that to the client. But in about half the states, that's not, that would be done with risk. You actually, that's limited to licensed practitioners and registered dietitians.
Fantastic. That's awesome. Yeah, because lab work is just coming, it's just becoming more and more accessible. So it's good to know, while it's becoming more accessible, there are still restrictions around, what we should be doing and what we shouldn't be doing. That's very helpful. Let me scroll through. We've got about 7 minutes left. This is going by so fast. So while we scroll through this chat, I do want to just let you know again, not again, but I kind of teased at this, and this will go out in the replay. The replay is going to go out tomorrow, okay? So that way I can collect all the different resources that we've discussed, and they can go out. It'll go out tomorrow.
Let me clarify one thing. I saw someone writing in, just a quick thing to clarify here. So just so you know, I don't want to call the person out, but licensed professionals cannot guarantee results either, okay? They shouldn't and they can't, and they usually don't if they're ethical. But what they are allowed to do is to say, science has proven this cures cancer. Science has proved, whether you agree with it personally or not is a whole different matter, okay? But like doctors are allowed to say, research has shown that chemotherapy cures breast cancer. You may not agree with chemotherapy whatsoever. You may not take that approach whatsoever as a health coach or a holistic practitioner, and that is totally fine. But what the law says is that because people come to doctors for their medical expertise and they're trained in a certain way and they're licensed in a certain way and they're regulated in a certain way, people come to that doctor for the doctor's knowledge and expertise about their situation. That's why doctors are allowed to cure and prevent and treat illness, because it's based on the imbalance of power and knowledge that the doctor has, and people are, the same is true with accountants and lawyers and others as well. That's why we all have these millions of ethical regulations and rules and all these licensed professions that we have to follow, because there's an imbalance of power. With a health coach and a client, you guys are actually technically peers, okay? So doctors can't guarantee results and shouldn't, but they can actually make medical claims that this could help cure or reduce cancer, because someone who's diagnosed with cancer looks to the doctor and say, what do I do about my cancer? In the holistic world, we're just not, the laws have not evolved that way yet. You guys know we are all way ahead of the game here. And the laws are always way behind. So just please know that's why there's a distinction between the two.
Fantastic.
That's helpful.
Yeah, Lisa, this is all gold. There's so many gold nuggets in here that I'm like, oh yes. It's just like all of a sudden, I don't know if everyone else is feeling this way. I know what we're talking about is bringing up more questions, because I mean, it's a big topic, right? And for the most part, we feel alone trying to figure this stuff out.
Yes.
But hopefully there can be some clarity on some of the big points. And again, Lisa's got a whole host of resources that will be linked in to the replay that's going out tomorrow, with either where you can book some time with her privately, or where you can see some of her done for you, do it yourself, not done for you, but do it yourself work. So before we end this call, we might be able to squeeze another one in. I'm not quite sure, but we'll see. But Lisa's giving everyone, all the Practice Better users, so the ones joining us today live, those of you joining us for the replay, 25% off all of her single do-it-yourself legal templates. So if you're still getting set up, or you're not quite sure if you're already using the right documents, right? You're not confident in what you've set up to protect yourself, you can check out her do-it-yourself legal documents or templates, pardon me. Customize them for your own needs and for, you know, how you're practicing. And you can use the code all in caps, practice better. You should all be able to remember that, but it will go out in the replay. Practice better, all in caps, to get 25% off those single do-it-yourself templates. That actually brings up one question I get very frequently, and that is, if you're doing a client agreement, right? Do they all have to be personalized, or can you write, if everyone's signing up for a package or a program, a one-on-one program, and these are the things they get, everyone gets the same thing? Do you have to customize? Do you have to write their name and everything into that agreement, or can they simply sign the same templated agreement?
Yeah. Okay, so in a traditional sense, you would have their name and address in the document and your name and address in the document, because there's usually a section on notice, or if you have to contact that person, and it's already indicated in the document where and how you contact them. And it's in the ones I create, they're also updated to include email addresses so that email can be a form of contacting the person. Right. So the way I look at that, Natalie, is ideally you do want to put the person's name in the document, and you want to have the date in the document, or your documents, I know if you practice better, when you print them, they have the date produced for you. As long as you can prove a date the person signed. So ideally, yes. But what you don't have to do is let me restate that. If you have, let's say you have 3 programs, 3-month program, 6-month program, 9-month program, I recommend you have versions of your agreement for each of those programs. But everyone who signs the 3-month program, you're just going to insert their name or their email address or whatever it is, and then you send it off to them. That's it. That's all you have to do, because everything else is in there. Your program description, your payment, what happens if they miss a call, what happens if they miss a payment, governing law, notice, disclaimers, limitations of liability. It's all already in there. And then you do version for the 6 months, same thing. And then you do version for the 9 months, same thing. So that's how I would answer that question.
That's awesome. So in practice better. So that doesn't mean you have to go in and type in their name. You can give them a space to type their own name in.
Oh yeah, that's fine. Just as long as their name is in there, because otherwise if you don't have their name anywhere on your lease, it's very hard to prove like this person agreed to this and you knew it was them. You can't read signatures sometimes. People's signatures change over time. Believe it or not, just if their handwriting changes or they're aging or they have an illness or whatever. So you want to just make sure you have your name and their name in the document. And it is important that you both sign the document. And it's important you both, remember, get a signed copy of the full document at the end. So no one can argue that this is not the same version that you both got.
Right. Fantastic. So just last thing on this, in practice better, when there's a signature required, they have to write in their name if you are ready. So that's required. But if you want to double up, you can insert a personal information section where you also ask them for their name.
That would be ideal.
And then, yes, everything is tracked, is dated. When you print out that physical copy, if you wanted to, the date will be there as well. Awesome. All right. I know there are a ton of questions we didn't get to today. We will definitely be having Lisa back. Because we could talk about this, I mean, not even just all day, we could talk about this for days on end. But we so appreciate your time. We so appreciate you going through this with us and really giving us some clarity on some of these huge, some of these questions that end up being big barriers, right, in our practice and building our practice and our confidence. And so I really appreciate that. And on behalf of everyone joining us today, thank you so much for spending the hour with us.
Thank you all so much for taking the time to be here. Thank you, Natalie, for hosting. The work that you all do as a holistic practitioner myself, on the one hand, is so important, and getting yourself legally protected using really easy legal documents to fill in that are already designed for holistic practitioners, and getting yourself so that you feel safe and secure and confident and clear is so important, so that you can relax and let down and go out and expand your business. So I'm here, my team is here to support you and help you. Like Natalie's going to share the podcast, the book, all these resources available for you. And just thank you all for the work that you're doing. And thank you so much, Natalie, for putting this together. I sure hope it was helpful.
I guarantee you that it was. Awesome. Thank you, Lisa. Everyone, take a look out for the replay tomorrow with the promo code and all the resources. All right. Have a fantastic day, everyone.
Thank you. Bye.
Bye.